Modern Real Estate Practice, page 114. Probate. Probate is a formal judicial process. Probate proceedings take place in the county in which the descendant last resided. If the descendant owned real estate in another county, probate would occur in that county as well. The person who has possession of the will presents it for filing with the court. The court is responsible for determining that the will meets the statutory requirements for its form and execution. If the will was modified, or if more than one will exists, the court will decide how these documents should be probated. The probate court acts on its own violation as well as through the executor named in the will, or an administrator or personal representative appointed by the court if there is no will, or if the will fails to name an executor. The court publishes required notices of the pending probate, proves or confirms the validity of the will, including ruling on any changes to the will, determines the precise assets in the estate of the deceased person, and identifies the people to whom the estate's assets are to pass. The purpose of probate is to properly allocate and distribute the assets of the deceased. All assets must be accounted for, and the descendants' debts must be satisfied before any property is distributed to the heirs. In addition, applicable federal estate taxes and state inheritance taxes must be paid before any distribution. The laws of each state govern probate proceedings, as well as the functions of the individuals appointed by will or the court to administer the descendants' affairs. The specific persons entitled to property and the various percentages involved vary from state to state. In practice, a real estate broker entering into a listing agreement with the executor or administrator of an estate in probate should be aware that the amount of commission is approved by the court, and that the commission is payable only from the proceeds of the sale. The real estate broker will not be able to collect a commission unless the court approves the sale. In some states, the probate process is not unduly cumbersome, but in other states, it can be lengthy and expensive. One way in which property owners can avoid the delay and expense of probate is by establishing a living trust while still living and transferring title to real and personal property to that trust. In a revocable living trust, the person establishing the trust is the trustor as well as the trustee, and the terms of the trust can be changed at any time or terminated during the life of the trustor. On the trustor's death, the trust need not go through a probate proceeding, as title automatically passes to the beneficiary named in the trust. There are many more details to creation of a living trust, more than being covered adequately here. The advice of an attorney should be sought to create the trust, to successfully transfer property to it, and to file the necessary documentation on the death of the trustor. It is important to have all the trustor's property be transferred to the trust, or part of the estate will still have to go through probate. The living trust also has no effect on the value of the estate for estate tax purposes.